Previously on The Business.
All right, let's talk more about things which you probably don't really put as top of your priority list when it comes to starting a business, owning a business, being in a business with. However, long term, or sometimes short term, that can come back to bite you rather nastily. Today, I'm very pleased to welcome our two guests into studio. First of all, thank you for braving the potholes, the rain, the e-tolls, and everything else in your way to get here. Theo de Bell is a director at Bowers Attorneys. Theo, good morning. Welcome to you.
Good morning to you too.
And welcome to Andrew McCabe from McCabe Attorneys. Great to have you in studio this morning.
Thanks for having me.
Welcome to both of you. We're talking about intellectual property. That's kind of the overriding, the umbrella of this topic this morning. And it's something which, let's be honest, when we start companies, when we start our businesses, we're not really thinking about it. It's not top of our priority list. Let's start with you, Theo. Do most businesses, do most people, clients that come into your office have a kind of a grasp as to what they need to do in order to protect their intellectual property?
In fact, no. I think internationally, not just in South Africa, but small and big businesses are often totally unaware of the real meaning and content of intellectual property. So they would often walk into your office and say, I want to copyright this patented trademark, and mixing all the different forms of intellectual property all in one.
Yeah, that would be me, by the way.
and you then often have to like dissect and interrogate them before you realize that A, you can help them, or B, no, I can't. So actually very few people spend time and effort beforehand at it, and usually by word of mouth or word referred to or say, shouldn't you? And then they start looking either on the internet or the telephone book for somebody.
So you've hit on a really important point there, the confusion between these words. Would it be accurate from a layman perspective, just to set the context for our discussion going forward today, to say, imagine intellectual property as this category of legal protections that you can get, and perhaps think about it in terms of there's copyright law, there's patent, there's trademark, and there's design. And those are the four acts that really govern what you do every day. Would that be a way to look at it?
Yes, well, that's basically what covers what we do. But intellectual property law is basically, intellectual property is the property that basically comes from the mind. So stuff you think of. So if you take a picture or an artist, or you design a new thing, or you've got a business, if you've got a wonderful name, Bowls Radio, that would be something you need to protect, intellectual property, as opposed to tangible property such as a table or something like that. Copyright, designs, trademarks, patents, that's subsections of intellectual property. But the main thing is to realize that you need to protect. It's for us as attorneys to decide what we call it. You just need to know that, okay, I thought of something, I need to protect it now. And then you come and see us. It's really not that important that you know this is a trademark, I need protected, or this is copyright, I need to protect it. The main thing is that you realize I need protection for my mental thing I thought of.
Do you think that people tend to think in terms of something tangible, though, being protected? So if they're in the products-related business area, it's something that might occur to them. But the services-related businesses are slightly different, and perhaps that's where there's a bit of a weakness in terms of people not protecting themselves, and in fact they can.
Well, it's basically any business, whether it's services or products. Unfortunately, what happens is people are very excited, startups, they start their business, they've got wonderful ideas, and then suddenly somebody infringes upon their rights, whether it's a patent or whether it's a potential trademark, and then suddenly they want help. And then often it's too late, or we then have to take steps, and then they have to go to the extra expense, whereas if they, when they started up, went for advice, they wouldn't have had to go through that problems. All right.
Is it not that people starting out a business, or even 2 or 3, 5 years in, just simply don't have budget put aside for things like trademark, things like patents, etc., etc. And as I said right from the beginning, it's kind of sidelined. It's something that's not really necessary. And when it comes to it, and it comes down to somebody taking that idea from them, all of a sudden they have to suddenly get involved with you guys.
It's a matter of balancing your priorities. In business, you'd have to decide, okay, I need an office, okay, I need a secretary. The thing is, we need to get it across to the public that when you start a business, you have to look after your intellectual property. Unfortunately, people don't know about it, but it's an actual fact more important than having that secretary or having that nice office. Sorry, yeah.
So would
And
it be
it's-
part of your business plan then? I mean, are we
It's-
talking about a
it's-
line item on your budget?
Absolutely, it's part of your budget, and as your budget grows, and as your turnover grows, and your cash flow, so you deal with it. So you have to prioritize. For example, with an invention, if you created an invention, you cannot patent it once it has been disclosed. With a trademark, you can start using it and over time protect it. But again, then if you become known, people may perhaps preempt it and develop something similar, or create a name that would be passed off as yours. So it's important for you as a businessman to have a blueprint, to have a strategy and a policy, and appreciate the various assets that you are playing with, and develop your budget as time goes on, how you can protect it, how you can expand it, etc. Something that is very important as well is not just your own assets, your own intellectual property and the rights that you must take notice of. You must also take notice of those of third parties. So if you, for example, enter a market with your name and your product, you may in fact infringe on the rights of another's names and products.
You're talking about a territorial thing or
quite
regional
right. So not
impact.
only are you careful to protect what is yours, you also must take care not to infringe on that which belongs to others.
Does copyright come into play automatically in South Africa versus patent and trademark, where one has to go actively to register the protection?
Well, it's important to understand that you don't always have to protect. And it comes back to the budget thing.
Mm-hmm.
You can overprotect, and I've in fact seen in history more people going under financially because of overprotection than underprotection. We joke and say there are three prizes. The worst prize you can get is that somebody else has the right, has monopolized that space, whether it's a name or a product or a service, and that you can't enter it at all. So all the investment that you've made is for nothing because you have to stop. That's the booby prize. The second prize is that, well, you're making a hamburger and somebody else may make a hamburger, and you may call it what you want and he calls it what he wants or she wants, and you compete in the open market. It's just a normal competition space. And then there's the first prize, is when you can actually monopolize your product or service and exploit that in a monopolistic environment. The other thing that you must appreciate is that the law of contract and the common law is as important as these statutory rights and registrations. So, for example, your contract with your employee or your employer, or with your service provider, or with your contract or your business associate is often as important from an intellectual property perspective as those protections in terms of statutes.
So from a layman's perspective, gentlemen, we tend to think of copyright as something that protects the literary works, the creative works, the design works, and those kinds of things. Theo, when we start talking about patents, though, what are the kinds of things that one can patent?
Well, a patent is typically for an invention that is useful in industry or agriculture. It must be novel, it must be inventive, it must be useful, and it must not fall within those specific exclusions that are also provided for in the Patents Act, such as business methods and discoveries.
So those are not patentable.
Those are specifically not patentable as such. At the same time, when you come back to the copyright element of it, so you may have described something or written a document with a whole host of technical information, or you may just have done an engineering drawing on a product. Now that drawing is then protected by copyright, typically, automatically, while the invention that you described and drew in that drawing may be patentable. So it's important that you also appreciate, and comes back to your earlier point, of where people get confused between tangible and the intangible as in intellectual property, that they regard the intangible often as atangible. So they think it's an either or, where it ain't. So if you look at your cell phone can encapsulate software, protectable by copyright. It has a name, one of the well-known names perhaps, that is protectable by trademark. If there's a concept that is patentable, it could have been covered by a patent. So there are whole hosts of intellectual property or intellectual property portfolio often relating to a single tangible product or service.
What about if you're not sure that what you've actually created is novel, is an invention that is worthy of being patented? Where does the onus lie? I mean, you can apply to get it protected, and surely who does the onus lie on to actually prove that it is novel,
Well,
that it is something new?
You're touching on a very sensitive issue at the
Yes.
moment, that you may be aware of the new IP policy that came out by the Department of
Absolutely,
Trade and
yeah.
Industry, and there's a whole bunch of issues about it, including whether South African patent model should develop into or should be evolved into a so-called substantive examination model.
And what would that mean? Substantive
That means
examination.
that when you file your application, the patent office will examine it substantially to determine whether it is your invention, as described in your patent application, is both novel and inventive relative to what is out there before, the so-called prior art. Where at present, we have a filing system. Provided you file the necessary documentation, sign on the dotted line and fill in all the blocks, you get a patent granted. But if it has worked relatively well in the past, and the system has taken notice of South Africa granting patents that have not been examined substantively.
So
But
there could be people in South Africa running a business who believe they have patent protection, when in fact in another part of the world they wouldn't be.
Absolutely. Sometimes that very product is known in South Africa or elsewhere, and the person either knowingly or unknowingly filed a patent and got a patent for an invention that he believes he can enforce the rights of. Where he then finds out when he tries to do that, the other side says, I'm sorry, I'm defending myself in the fact that your patent is invalid because the invention that you patented was known before.
That's a minefield of litigation on the horizon, surely.
Well, lawyers must also live.
Yeah.
Let's talk. That's very funny. Let's talk more about trademark. Let's talk about brands, about logos, about slogans, about all of those nice things that come with
absolutely.
starting a new business.
Hours that go into,
Oh, yeah.
should we have it this color and should we have
Yeah,
it
yeah.
that shape?
Absolutely. People starting out a new business, people in a business who haven't really paid much attention.
Yeah.
Let's go there for a second. Talk us through it.
A trademark is a fairly simple thing once you understand what it is. A trademark is basically that which you use to differentiate your business from another person's business or another
Identity?
company's.
Your
Yeah,
identity?
In other words, let's take this radio station, Balls. That would be a trademark to differentiate you from another company or another radio station.
Okay.
So anything you use to differentiate you. So to speak in jest, if Ian had smelly feet and that was an exceptionally unique aroma that was just associated with balls, and you could get a chemistry specialist to take that, bottle it, and register that, and people, when they smell it, they associate it with Balls Radio, you would be able to register that as a trademark. Sounds, specific jingles,
Yes.
you can register that as a trademark because you use it to differentiate your company, your business from your competitors.
So we're talking about a brand name, a logo, a slogan,
Yeah,
a shape,
shapes.
a sound,
Yeah.
a smell.
Yeah, yes. Jingles, anything basically that you can put into writing basically in a formula. So in other words, smells, you can put it in a formula. It's not done that often, but you can do it. Generally, people would think of a business name and slogans
Yes,
and logos,
the obvious
and you would
things.
take that. But basically anything to differentiate my company from your company.
What if I want to? What if I've started a business and I want to trademark the smell of cut grass? It's something which everyone knows. It's something which everyone has grown up in South Africa with all the lawns and open air. We all know what the smell of fresh cut grass is.
Yeah.
What if I want to trademark that?
Well, the thing with all IP is it has to be distinctive and it has to be fairly novel. So you've got a little bit of a problem with cut grass, but if you associate the cut grass, say, with a radio station, nobody inherently would
Yes.
see that
Yes.
as associated with a radio station. So you would have practical problems as to how you're going to get the public to associate cut grass with balls.
Right.
But theoretically, you could do that.
Very interesting.
Hasn't the sound of a Formula One car been
Sound of a
protected?
Formula One car
Yes.
has, and funnily enough, the sound of a Zippo lighter. I don't know if you're familiar with the sound of
Yeah.
that clink. Has also been trademarked,
And I believe the Harley Davidson.
and the Harley Davidson.
But it's important to distinguish appreciate that with an invention, if you want to patent it, you have that novelty requirement.
Yep.
Where perhaps with trademark is that it's available for use, for you yourself, with relation to your product or your service or your company. So coming back to cut grass, the smell, the name Gorilla perhaps, or Star or Southern, you can pick those, and they are all known terms And if they are capable of distinctive, as Andrew indicated, and it's available in that particular class of goods or services, then you can register it. So it's cardinal to appreciate what are the so-called requirements to protect and use those trademarks or inventions or designs or whatever that makes it lawful for you to use. Because remember, at the end of the day, in South Africa, copying is lawful. So unless there's an element of unlawfulness, another may copy. And that's cardinal.
So ordinary practice in business, companies generally will kind of look at their image after a few years and they say, well, we need to change our CI, our corporate image, and they might introduce a different color or perhaps even go as far as a different logo, retain the same name. Is that a little pitfall where they perhaps are forgetting then that they need to update the protection they have, because the protection will have been done against the original logo and icons, etc., etc.
Absolutely. You often find that people exploit what they have not protected, a bit like building your house on your neighbor's yard or plot. So it's cardinal the first time, and then as you amend or make little changes. And you often find that people do those changes, but they forget, and they think the landscape is still like the day that they step off.
Right.
So that landscape of rights is a bit like building the first time in an open area, and your neighbors start getting tenser and closer and more dense developed around you, and you therefore have to take cognizance of the rights and the developments of the others.
I want to pick up on a point you made just now. You said it is lawful to copy in South Africa.
And most places.
Let's unpack that. What are we saying? Because you're not giving blanket permission for people to go and plagiarize or pirate things. So how does a layman understand what that actually means?
So in the absence of an unlawful element, copying per se as such is lawful.
Is it about intent?
And what are those unlawful elements that could be there?
Yes, what are they?
They could be either there in the form of a contractual obligation. So you are in breach of that contractual obligation. So let's call that the law of contract. You can be in breach of an remedy in terms of the statutory law, in terms of a statute like a patent or a trademark registration or copyright. Or it can be an unlawful element in the terms of our common law. You competing unlawfully. So even if I'm using a name and I've developed a reputation on it, with it, an association with that name in my product, but over time, I have no copyright protection, and I perhaps have no trademark protection. And then a third party comes and uses that same name. So copying per se is lawful, but now the public is being confused. They think, but this Balls number 2 is the same as Balls number 1 radio station. And they are then passing off, they're deceiving and confusing the public and thinking it is the same radio station. And that, from a common law perspective, is unlawful. So in the absence of an unlawful element in terms of either of those three forms or pillars of law, copying in itself is lawful.
Andrew, what's the weirdest thing that your firm has ever been asked to protect?
The weirdest thing? Well, that's a quick thing to ask. You'd have to come back to me. I can't think that. There's quite a few things. It would be a few smells and strange
Really?
colors
So there
and
have
stuff.
been
Yeah,
smells.
yeah. So that does happen.
There you go.
How do you document a smell?
Well, you would have to. There's certain formulas you use, but there is a chemistry table you use to
Right.
basically determine it. So you can't simply say the smell of cut grass. You would have to show the formula of the smell of cut grass. All right, which would then be registered.
Let's talk about expiry dates. Let's talk about things that expire. Once we've got our patent, we've got our trademark for our slogan or for our invention. How long does that last?
They're different for each category,
Yeah,
aren't
I'll
they?
start with trademarks and then trademarks. You basically have a 10-year period of protection from the date of filing. So let's say we file Balls today at 10 o'clock. 10 years from today, you would have to renew it if you still want to use it. All right.
Okay.
So if you're using it for 10 years and you wish to continue using it for a minimal amount, you would be able to renew protection of your mark. That's assuming it went through the registration process and it was accepted as a trademark.
Is there a standard fee for that registration?
No,
when you file the
it
papers?
differs. Well, you have standard rates from the companies and trademarks office, but attorneys differ. Most attorneys are fairly flexible regarding that if you contact them.
Okay.
All right. Yeah.
Okay, so that's trademark. 10 years.
What about patents?
So if we remember, the other one is copyright. Copyright in principle have a period of time. from whether it's a company or an individual, whether it has been published or not published, whether it belongs to this one or that one. But in principle, let's say 50 years after date of disclosure, death of the owner, etc. And it changes a bit from country to country. If we could quickly touch on that, internationally, intellectual property is a very similar animal. So it's a bit like the rules of rugby or soccer or cricket. It's the same rule, different countries just apply it a bit differently. But in principle, the rules are very much the same thing. Patents, 20 years from the date of filing of the complete application. Designs, you get functional and aesthetic designs, 15 years for a design, for aesthetic design, 10 years for a functional design. I just want to mention it's important here, and it comes back again to the issue of today, whether intellectual property is fair. If you on the other side look at issues like the interest of pro-competitiveness, overpricing, colluding in the marketplace, all those negative terms that are often linked to intellectual property. Appreciating that the intellectual property right in principle is granted and has been granted for eons. You get a Roman Empire that have granted something akin to a patent to somebody that came up with a new medicament, for example. The principle of intellectual property right is to give something in exchange for that development. So by telling the world how to solve a problem, how to overcome a difficulty, I get a right, a limited right for a limited period, and thereafter the public is free to use it. And it's that quid pro quo, as we call it, that exchange of what you contributed to the public, what intellectual property right in principle is.
When we talk about copyright, I've come across businesses and individuals who, will slap a little copyright sign onto documentation that they use. Can they do that? Is that a matter of ordinary practice that should be happening? Their argument being, well, it's automatically mine, so I can just put that little C there, and that's that.
Well, with copyright, it's usually fairly straightforward, because that automatically vests in the person that designs the copyrighted item. If you get to trademarks, you get different designations. You get a TM little sign, which I'm sure you've seen, and then the R designation. Now, you're not allowed to use the R designation until such time as you've been given a registration certificate by the Registrar of Trademarks. TM you can use basically just to indicate that you are the trademark proprietor, but it's an offense in terms of the Trademarks Act to use the R if it's not registered as a trademark, which lots of people make a mistake about. What we're also discussing now is we're going on about how we need protection against somebody else using our trademarks or our patents. But the big thing is also the other advantages you get to trademarks, to registering it. If you have a trademark, it becomes an asset on your balance sheet.
There's a value, isn't there?
You can sell it later on. If we take a chutney with a similar name to this radio station, that was sold a year or so back for, I think, approximately 400 million rand. And that's what entrepreneurs need to realize. When you sell your business later on, that is an asset that you can sell together with your business. Right.
And how you evolved that, and how you packaged it, and how you protect it, enhance therefore the value of that asset base. And it's what makes you attractive more or less to another.
What about .coms, .nets, whatevers? What about the world of the internet? Does this start to become a little bit more difficult, or is it pretty cut and dry?
Well, still you need a trademark protection. The good thing about a trademark is that would give you protection basically against anybody. So let's say you've got your radio station trademark and somebody else comes with the internet, with another internet-based radio station. You would be able to stop them from using balls as a .com or a whatever.
Yes.
All right. So you would have protection regarding that.
Automatically.
Yes, if you have a trademark registered.
Yes.
All right.
What about somebody who's in the field of design and development? I mean, this is a huge area of growth in terms of young developers, for example, who are producing apps. What type of protection should they be investigating for software applications that users download either onto a desktop or a laptop or a tablet or a phone?
And it's an extremely complex environment, because historically those exclusions that I referred to earlier that are excluded from patentability, software and business methods. And now we're moving into the world of computer-aided or assisted business methods.
Business being conducted through that software.
Exactly. Whether it is your medical aid claim or whether it's this or that, it's all at the end of the day more and more some are the financial and the service, and the financial services are a very good example of it. That is at the end a computerized business method. And internationally, this has been patented extensively. The joke about the one-click business transaction, etc. There are a whole legion of this. And internationally, is again a huge debate to what extent should the world provide patent protection to this. And if you look at the patent portfolios that are being sold between the Googles of the world and the Microsofts of the world, they are worth hundreds and hundreds of millions of rand and dollars in that. It is very difficult because historically, for example, in the whole space of technology transfer and concept, it was on hard copy. It was conveyed from one to another. Now, by the click of a button, you can distribute that idea, that concept within detail or just an elementary internationally, immediately.
Well, yeah,
So
you
to capture and
upload it, you
protect,
make it available through
quite.
one of the stores, Android or Apple. And it's a question I hear from young developers all the time. Once I've put it on that store, how do I know somebody else isn't going to steal the idea for what that app performs, what it does, reskin it, recolor it, give it a new name? Is there protection? I mean, what should they have done? If they really want to protect, is there protection as we speak today for
I
that?
think what is important, you must remember that protection is not necessarily absolute. The law recognizes certain forms of intellectual property. The laws are slightly behind technology, as we know. It plays catch up all the time. So as the technology develops and enables people to do certain things, the law is still coming behind as it involves in certain structured boxes, pigeonholes if you want. So you come up with a concept, and elements of that concept or elements of that intellectual property that you came up with are protectable by any of those specifically recognized forms of statutory intellectual property. Your common law play a bit of a role, and the rest you play catch up with your contracts. So to the extent that you can, you engage into contracts with your clients, your customers, your markets, your suppliers, your networks, your etc., to try and protect and recognize and protect you against confidentiality, non-circumvention, and elements like that. And perhaps a message that I would like to leave at the end of today is that don't undermine the protection provided by contracts.
I'd like to know how we go about doing all of this. Because we've spoken so much about the process, etc. Let's get down to the nuts and bolts of it. Let's start with you, Andrew.
Yeah. Well, the first step
process?
would be, as I said, you need to recognize you have a protectable interest. As soon as you realize that, then you contact either me or my colleague. All right. Then we basically decide what it is you need protection with. Do you require design protection? Do you require trademark protection? Is it potentially a patent you require protection with? All right. Then usually you conduct a search of the relevant register to determine whether it would be registrable or not.
The lawyers
Yes,
would
the
do
lawyers
that.
would
And
do
is where
that
the
to make
lawyers
sure.
come in, surely,
Yeah,
because you have
exactly.
access to those
Yeah.
kinds of databases.
So we do that. If it's registrable, we then proceed and apply for the relevant protection if we feel it's necessary. And the same, if we feel that you can get better protection simply by contractual means, then we assist you with drafting a contract. So the main thing is, even if it's just to know what your rights are, contact an attorney. It's again, you have to decide, am I willing to expend a little bit of money at the start to protect myself later on? All right. And as soon as you realize you have to do that, you go see your attorney, and then we take it basically from there.
And again, don't forget the rights of others. So as you have your business idea, your concept, your venture that you want to enter into, you consider your own asset or idea or concept that you want to exploit, whether it's a product or a service, as well as those of others, so as to determine whether I'm in the booby price or in the first price or in the second price space. Would I infringe on others' rights? And what must I do to amend or adjust my own venture to be able to enter into the world of commerce lawfully? And because often by knowing what the others have done, you can amend and adjust your own to still exploit, to still enter the business space.
Couple of questions in on Twitter. Kriya's got all of those details. Do you want to just read some of them out?
Yeah, I got 2 questions here from Mike Jansen. He asks, can you challenge a trademark registration after the published notice has expired? And can you trademark a Twitter handle?
So those are the 2
Let's
questions.
let's deal with
each
each.
one.
Yeah.
So can you challenge a trademark registration after the published notice has expired?
Yes, you would. It would depend on the circumstances, and I can't go into everything now, but in theory you can. All right, and in practice, you can also do that. So what I advise is that he contacts his attorney so that one can have a look at it. But you definitely can.
So what's happened
it makes
in that
it
instance?
makes it more difficult in the
Yeah.
sense that you might have only realized afterwards that there's somebody that's infringing on my right. But we work in South Africa on the principle of prior in time, prior in right. So if they were using the mark before the registered trademark has used it, he would have a chance to basically oppose it even afterwards, if he only came to know of it afterwards.
And then the second one, I think it's a sideline question from him. He says, can you trademark a Twitter handle, for example?
Yes, you would be able to if it's distinctive. No, okay, simply something as hashtag your name and there's other people, that would not necessarily be trademarkable. But if it's a very distinctive Twitter handle, you would be able to trademark it. Yeah.
My question is, just while we've been talking, I've really been thinking hard about this, and it's a broad topic, but there's been such a downfall in the traditional music industry.
Yes.
Due to the fact that people are copying songs via what started out as Napster has now become file sharing, etc. Is this an example of an industry which didn't pay close enough attention to technology and is now trying to catch up and has lost millions upon millions of dollars?
Sure. To some extent, I suppose it depends on who you talk to in the music industry. I know some musicians see the open field now that you can basically get your product out there.
Become democratic
exactly.
in terms of
In
publishing.
other words, I
Yeah.
copy, but now instead of just having one person buying your CD, suddenly you have 20 different people listening to your album or your song. So it really depends on who you talk to, whether it's a good thing or a bad thing. For the music, for the production houses, I'm sure it's not a good thing, as in Sony and those kinds of places, without mentioning names. But they would not be happy with it. Okay.
And I think one must distinguish between whether you have rights that are enforceable in law and whether by the very nature of how it is disseminated or spreading, whether I can effectively enforce those rights. So the internet and the world of music have become impossible to a large extent to enforce those rights that a musician or a songwriter do have, but they just is impossible to enforce. So, and it's an element that you often have to consider when you roll out your business or decide on your business is what elements are protectable, but also what of them are policeable. So if I can't effectively enforce my rights, don't spend a lot of money on it.
That unpoliceability, and I know it doesn't exist as a word, but that's becoming more and more common. The internet is something which, how do you police all of it? You just can't.
And they talk about the public domain and whether it's open
Right of
out there,
use and
you know,
yes.
and we often interpret as that we do have a right of use just because it's nearly impossible to affect that protection. And you know, things like copied CDs and black market this and black market that, one still has a feel of guilt when you get involved, but that area is getting grayer and vaguer very, very quickly.
Theo, Andrew, it might be an unfair question, so feel free to say so if it is. But it's something that I think is so relevant given how digital the world's become and how businesses are engaged in digital. Creative Commons licenses, which a lot of people are saying is the solution to copyright protection in the digital space. What can you tell us about Creative Commons licenses and how they fit into this discussion, if they do at all?
Well, the Creative Commons license, it started off with the company. So it's purely the name Creative Commons, which is a non-profit organization in America, where they created certain copyright contracts to limit the copyright which you grant to other people. All right. So you still give everybody a chance to use certain photos, etc. So Creative Commons licenses, it's a good thing, and it opens up trade, and people can start using different things. Like on Google, if you type in for a certain picture, you get certain pictures you can use. That's a prime example of what can be seen as a Creative Commons license.
But they are limiting usage, aren't they? I mean, they're levels of usage.
Well, remember, at the end of the day, the intellectual property has been created and it belongs to somebody.
Okay.
And there are rights vesting in those people, subsisting in those works. But to overcome the difficulty of the modern world, of the internet, of the spreading of information, etc., the commercialization of that somebody came up with a business model to say, I'm going to commercialize it by means of these open licenses. So rather, and it's the same with the so-called wrap licenses or clean wrap licenses or one-click licenses, etc. Somebody came up with a methodology to try and generate, according to their business model, a revenue stream from the use of what otherwise is very difficult to police. And that is their way of commercializing. And perhaps on this, we can just touch on the three elements of intellectual property. The one is protecting it, or creating it initially, obviously, protecting it, defending my rights, but at the end, I want to commercialize it. If I don't generate the revenue stream with the use or the indirect through others' use, then it means absolutely nothing. It's just an asset in the cupboard.
Let's leave it there. What a lot of stuff to think about.
We probably need another 10 interviews.
I know. Let's direct a question to you, Andrew. How can folks get hold of you if they want to get in touch with your company or you personally? How do we do that?
They can go onto my website. It's mccabeattorneys.co.za. Alternatively, pop me an email at amccabe@mccabeattorneys.co.za.
All right, cool. And Theo, how do we get hold of you?
Well, it's the law firm Bowers, Intellectual Property Attorneys, Bowers Inc. And again, similarly, go into the website www.bowers.co.za or contact us at our telephone numbers or email addresses.
Fantastic. Gents, thanks so much for coming in this morning. We really appreciate it. What an interesting conversation. And I do hope
Thank you very much.
that folks who are listening can take something away from this and perhaps use it to their advantage when it comes to building a business.
The Business on Balls. Weekdays 11 a.m. to 12 p.m.
onballs.co.za.
Brought to you by FNB Business Banking.